Welcome back to Legalese 123, where we are covering cases across America. Hello, and welcome back to Legalese 123. I'm your host, Missy K. I hope everyone is doing well on this Thursday, the 9th of July. Yay! Yes, this is my second stream of the day. Who am I? Well, I thought, I don't know if I ever told anybody who I am. Who am I? Who are you? I am a law nerd at heart. I call you my law lovies because law nerd is pretty much taken by Emily D. Baker, who is the queen, right? I appreciate her. I appreciate everything that she does. But I am a journalist who is now taking my opportunity to cover cases that I truly appreciate. I do have an affinity for the law. And so therefore, I want to bring you me, my cases, etc. So, how is everyone doing? Oh, okay. I got a message on here. Let's see. What did I say? In the Fraser Bohm case, it's Neve, not Naima. Interesting. I'm just trying to do it phonetically, so if I have it wrong, let me know. Hello, everybody. So, what are we talking about right now? So, yes, I was already on I covered the Courtney Clenny case that happened earlier today. We are now switching gears to Raul Valle. Missy, who is Raul Valle? Well, Raul Valle's case is out of Milford, Connecticut. Raul Valle was a teenager at the time. It is called the Preppy murder case, right? Oh, that's your cousin? Oh, I'm so sorry for your loss. Oh, I'm so sorry for your loss. I hope that you get the justice that you seek in that case. I know it's hard. It's hard. It's so hard. It's so hard to wait for these cases to go to trial. There are so many legal wranglings behind the scenes. Someone on TikTok was talking about the Fraser Bohm case. I covered it, just kind of went over what the last hearing was and the status on that was. And they informed me that I was pronouncing their cousin's name wrong. I apologize. I was trying to do it phonetically. Thanks for correcting me. So I'm very sorry for your loss. That is a very sad and tragic story. If you don't know about the Fraser Bohm case, he is the person who is accused of going 104 miles an hour on Pacific Coast Highway and crashing his vehicle into other vehicles, and that then killed 4 Pepperdine students. And one of those students is his cousin, which is very sad. So I hope that there gets to be a resolution in that case at some point in time. All right, so we're talking about Raul Valle. Raul Valle is the Preppy murder case. How is it a Preppy murder case? Well, that's what the press deemed it. Raul Valle is a teenager at the time. He and his friends were at one party for his high school. They are in a chat group with another competing high school. It's kind of like rich preppy kids go to one school, the other kids go to the public high school, and they're sort of rivals within sort of like the same district or same area. If I'm mischaracterizing it, I apologize, but I'm just trying to give the bare bones of the case. Raul and his friends were at one party. These other 2 boys from the preppy school came over. There's a fight that ensued. All the boys were told to leave because it was actually a girls' party for the volleyball team, I think. They were told to leave. They go away. Then the boys who came from the preppy school started egging on the other boys, Raul and his friend, through a group chat, a basketball chat, I think it was. and, telling them to bring it on, etc. I have a timeline that somebody made. Very, very, very nice. So between 5 and 8:30 p.m., the Lazy Brook House Party begins. The Lazy Brook house parties are by St. Joseph students. There was alcohol present. The Lazy Brook House is the first house where the girls were having a volleyball party. Ryan Hines, Jack Schneider, Raul Valle, Tyler De Silva are in attendance. Ryan says Snyder took a beer, tensions flared, Snyder got punched or shoved. Two of the girls quickly helped get that fight away. So Jack Schneider confirms fight with Hines started in the chain of events. So the fight ends around 8:30. Between 8:30 and 9:30, the fight ends. Tension escalates. The teens leave. They were all teenagers at the time. The teenagers leave. Tensions build up. The group chat starts to light up with taunts and threats. So if you're just joining me, we're going over the Raul Valle case. Raul Valle was actually tried once already. He is now up for a retrial. Sorry, I'm just telling people that I'm live. Join me. I'm also live on YouTube and Facebook. If you want to join me over there in just a minute, we are going to go over the motion to dismiss from his new attorney. But I am giving you a synopsis of what happened, trying to give you bare bones. Let me know if you know about the Raul Valle case. All right, so the group chat starts to heat up. One people tell the other people, go to Laurel Glen. Laurel Glen is where the other party is happening. The preppy party is happening. Go to Laurel Glen. There's approximately about 30 teenagers at the Laurel Glen place. That is where the preppy people are at. And I forget what the preppy people I forget what the preppy people's I know St. Joseph was the one high school. I forget what the other high school was. Okay, so long story short, Raul Valle, Snyder, and De Silva pull up to Rich's house. And then Tyler Rich. The teens swarm his vehicle, yelling, banging, spitting, throwing bottles. They go back and forth, and around 11:45, Raul Valle and De Silva exit the vehicle. Valle seems to be armed with Jack Schneider's pocket knife, or he goes back. There's been testimony back and forth as to where the pocket knife came from, and then a brawl begins. And 11:47, multiple people are stabbed. James McGrath is stabbed in the chest. He is the one that passes away. Ryan Hines is stabbed in the side and the leg and the back. Faison Teal is cut in the arm, and Tom Connery is stabbed in the thigh. Valle says, "Oh my God, I think I stabbed 4 people. I didn't mean to." And people just say it was mayhem. All these people are fighting. It's chaos, right? Can you imagine 3 or 4 boys showing up to a house that there's 30 plus people? They say there was 30 people. There might be even more. There was alcohol present at the Laurel Glen place as well. There were no parents in sight. It's chaos, right? All boys, right? All boys. et cetera, from rival schools. So let me know in the comments, have you heard of the Raul Valle case? He was tried last year, and so the trial was on July 9th, 2025. There was a verdict. He was acquitted on serious charges. He was found not guilty of first-degree intentional manslaughter, and 3 counts of first and second-degree intentional assault against the surviving victims. They were deadlocked in mistrial against the lesser included reckless offenses, and this resulted in a mistrial specifically for first-degree recklessness of manslaughter, 2 counts of first-degree recklessness assault, and 1 count of second-degree reckless assault. So now the prosecutors are like, okay, you didn't convict him on this. You had a mistrial, deadlock. You couldn't convict him on this. So we're going to retry him. So this is the prosecution's chance at a second opportunity to get them. Oh, so now that they have the new charges, his old attorney, I believe his other attorney name was Kevin Smith, and he did an amazing job. That was a huge trial for one lawyer to go through each one of those witnesses. If you didn't watch the first trial, it was bananas. It was bananas. There were so many people testifying, right? You've got the 3 victims who he stabbed, plus his people, their people, first party, second party, just there were so many witnesses, plus the police, plus all of the other stuff. It was a very, very long and exhausting trial. Okay, so what is he charged with right now? Okay, he is got 4 charges against him. He has 1 count of first-degree reckless manslaughter for the death of Jimmy McGrath, 2 counts of first-degree reckless assault for stabbing Ryan Hines and Thomas Connery, and 1 count of second-degree reckless assault for stabbing the Faison Teal. So we are going to go ahead and watch his new attorney, Mr. Crossland, give his reasons why this case should be dismissed. And if you're joining me on TikTok, I'm also live on YouTube and Facebook if you want to join me over there to listen to the hearing. So it's called the Preppy Party Murder Trial. I don't like that, but that's the way that it is, and that's the way that it goes. And I don't make up those things. Other people do. It's fine. And they said they're calling it Groundhog Day over again. Why? Why would they call it Groundhog Day over again? Because it's his second foray into this case. All right, so we are going to go ahead and start this up. If you want to join me over on YouTube, same channel name, and we're going to listen to this, and I'll pause and give you a quick synopsis with TikTok. But before we do, make sure to do the likey, the subscribey things, the heart things. And if you don't follow me, please do. Plus, also turn on your notifications because you never know what's going to pop off. There is some Karen Reed stuff happening right now. I'll deal with that later. I've got to go through these other cases. All right, here we go.
We can't use that courtroom today because a criminal trial takes precedence. So when that happens, we have to share this court, Part B.
Okay, the judge is saying they have to share the courtroom.
If either you gentlemen want to sit down? Yes. Sit down, sir. One housekeeping matter before we begin.
Okay, so just to let you know, this is the Raul Valle motion to dismiss. This was back in June. June 1st is when this transpired. I didn't get to see it. We're playing catch up. And no, the judge has not ruled on this motion to dismiss just yet. The judge said he was going to take 90 days to make a decision. And as of today, he has not made one. So we're about 38 days, give or take, that he has not responded. Just FYI. And if and when he does respond, make sure to like and follow because I'll let you know as soon as I know because I have my notifications turned on as to when it's going to be decided.
Mr. Valle, Mr. Crossland, I know you informed myself and the state that you were going to use a PowerPoint presentation in connection with your argument. That has to be marked as a full exhibit. So in the event the reviewing court wants to take a look at the arguments today, they will have everything that we have. So what I'm going to do is
also, this is my first look at Mr. Crossland. It's interesting to see each defense attorney's different styles and how they approach things. His name is Darnell Crossland, Crossland, and he is an African American defense attorney, and he wears a bow tie. I think it's super cute. But I'm very curious to see how he is going to compare to Kevin Smith, to see what has transpired.
I'm going to have this marked as defense one. This was the court's courtesy copy. And I would say within 2 weeks, by June 15th, if you can get the clerk's office, what is it, a compatible CD?
Yes, flash drive.
A flash drive? Can you do that inside of 2 weeks?
I can do that. Absolutely.
So that's the order of the court. This will be marked as defendants one, and if you can return it to me as soon as it's marked.
So Mr. Clerk, for the email as well, or just the flash drive?
Physical will be best.
All right, Attorney Crossland, you filed a motion to dismiss on certain grounds. Also, a follow-up memorandum that I received last evening. So it's your motion, sir. What would you like to say in connection with your motion?
Yes, Your Honor, thank you. I did, for the record, supply a response to the state's response. I know I have to so I just reserved, I guess, 2 minutes after the state puts on their response. But I did put the response as well.
Thank you. I have the court has 2. I have one dated April 15th, 2026. And I have.
Okay, if you're just joining me, we are going over the Raul Valle motion to dismiss. It happened on June the 1st, and I'm live on YouTube. If you want to hop over there, you can watch it with me, or Facebook. Same channel name, Legalese123. So I'll bring out TikTok. You can't see it, but I'll give you updates as we go along. Please make sure to like and subscribe. I'm going to say hi to a couple of people. Hi, no, not Bubs. Of course, I can't read all of these. It's hard to read people. Hello, Lorraine and Stella and Doris and Chrissy and Merchmaid and different users that don't have a name. Hello, everyone. So if you are just joining me and you want to see what we're talking about, you can hop over to my YouTube page or Facebook. Same channel name, Legalese123. We are going over the Raul Valle second bite at the apple in his motion to dismiss.
Dated May 31, 2026, and I also have 6 memorandums. So I use the term early before there, but it is a provisional.
Okay, I'm fast forwarding until we get to.
Say to the court that the motion accepted, so I don't think this court has jurisdiction again. So I think the retrial is later again. And I want to be clear with that. That's the breadth that I'm using. They do not have jurisdiction. So I think that's articulated in there, and I'll say it on the record openly that we object to the amended complaint and we object to going forward with the retrial.
That's the retrial is a much different issue. We'll get to that. I know you want to get to that. I'm just speaking of the threshold issue of the procedural filing of the amended complaint.
They're talking about his amended complaint. I'm trying to.
The grounds for the grounds for the objection is that when Judge Murphy made her ruling, the ruling necessarily encompassed exactly what's in the amended complaint. The amended complaint appears to me to be a repackaging of the same issues, the same charges that the jury has already spoken on. And so, again, without belaboring the point, I just going to agree specifically.
Okay, he's saying that. So, unfortunately, for the Raul Valle case, I can't get any of the motions. You have to get them from the court directly. You have to go to the courthouse. And I don't live in Milford, Connecticut. And I've looked extensively online. I could not find anybody who had given up the motions. So I don't know exactly what Mr. Crossland is trying to argue here today. So this is my first sort of look into it. I know that he's trying to say it's double jeopardy. I know he's trying to say that that the jury has already spoken on these other charges, so therefore he can't have these charges again. So he's talking about double jeopardy protections. That's kind of what he's looking at. So we'll see what he has to say.
That, because
I think counsel's a little confused, Your Honor. I think the court's question is whether or not this court has subject matter jurisdiction over the issue before it. This is the question that the court's asking, unless I'm confused.
If it's properly before the court, I have jurisdiction to hear the motion to dismiss argument based on collateral estoppel. If it's not properly before the court, I do not have subject matter jurisdiction to hear that argument or anything else connected to this.
So with that being said, obviously, counsel articulated whether the court has jurisdiction over the issue. And so the issue is not what's in the plethora of documents that I've submitted. The issue is just whether the court, who knows the file and knows the case, would make a ruling right now that has no jurisdiction, and then we go home. So I think that's what we are now. My position is that the state has no subject matter. The court has no subject matter jurisdiction because the issue is registered. The jury has ruled, and I think that's as plain as day. And if the court makes a ruling now, then we don't have to even go forward.
Okay, he's saying that there's a matter of subject matter jurisdiction. He's saying that this court doesn't have standing to rule on this case because it was in another court case, and that court case has been resolved. And so sometimes lawyers, what I like to call or say is they like double talk, triple talk over themselves to argue a point, to argue something else. And the prosecutor is adorable. He's like, Your Honor, I think he's saying that you don't have jurisdiction over this, and so therefore you can't that you can't rule on this. It's very confusing. And again, since I don't have the papers, I can't exactly see what he's arguing, and I'm doing my best to figure out what he's saying, and it's just like he's just talking off the cuff, right? So I don't know what he's arguing.
I kind of don't do things that way. I hear you, I hear the state. I do a thorough analysis based on the arguments presented before it. But I now have your objection, which is res judicata or something similar to res judicata. Prevents the case from going forward for the reasons that you stated, Mr. Durso.
The state believes this court does have subject matter jurisdiction to listen to arguments in counsel at this point in time with regard to the defense motion to dismiss. We would submit that this is proper for the court. The case is still pending. I think the counsel in his memorandum that he filed yesterday at 5.
Okay, so the prosecution is saying you do have standing, Judge. This is before the right court. So let's continue.
5 p.m. Indicated in that memorandum that the trial court's notified that the deadlocked jury did not terminate jeopardy, and the defendant never argued it did. So if he's conceding that point, that this is properly before this court in order to hear a motion to dismiss. If he's arguing that this is not proper before this court, then that's a separate argument that we need to have.
Okay, so the prosecution's clarifying it for you. It's saying, Your Honor, he's talking at both sides of his mouth. He's saying that if you don't have jurisdiction over this, then you can't hear his motion to dismiss. And that this is the proper forum to have this, so then he needs to do the motion to dismiss. And so he's trying to clarify and say, okay, Your Honor, at this moment, you need to decide which way are you leaning? Are you able to hear this case or not? Obviously, he is, because we know that the motion to dismiss happened.
I think the defendant concedes that, Mr. Moran.
Your Honor, just briefly, that's a misstatement. I think the memorandum says that the state's contention is that when a jury deadlocks, can the state go forward unless included? And my memorandum made clear is that obviously, yes, we all, as lawyers, we know that if jury deadlocks on a top charge, but that's less included, we can go forward, but it must meet thresholds. And the state now has not met that threshold to go forward. So the general question as to whether you can go forward unless.
Okay, this is really good argument. The defense lawyer is saying, did the prosecution meet the threshold when when not only they did so they charged the top charge, which is murder, and then they did lesser included. So he was acquitted of the M charges, right? But he wasn't. They were deadlocked or had a mistrial on the lesser included, and so the defense attorney who's advocating for his client. Remember, they take the spaghetti, they throw it against the wall and see what sticks, right? What is going to happen? So they're throwing everything at the wall to advocate for their client as much as they possibly can. So where and how can they get this case yeeted, right?
Included. The answer is yes, but they have to meet thresholds, and I argue that.
That's a separate argument.
That's the same.
That's a separate argument with regard to. He's
Excuse me,
subject matter.
can we do one at a time? I know council's passionate, and I don't want to take that passion because you won't be able to hear it directly when I pick up. So what I'm saying to you is,
Okay, the lawyers are arguing because they're talking over one another. That's cute.
I'm saying I conceded to jurisdiction based on the argument that he just made. First of all, that's not my argument, and that's not a concession. The argument was, there's no argument that you can go forward unless included if the jury deadlocks on the top charge, but you must meet thresholds. And I'm going to argue those in a minute, what those mean. So that's not a concession.
Listen, I'm not going to deprive you of your ability to argue. Subject matter jurisdiction could be raised at any time, including well past this matter, well past any trial. That's why I believe it's a threshold issue that I will address in a written decision. You've given me your position on it, and the state has given me its position on it. So now let's move into the second phase of the hearing, which is the items that you filed in connection with your motion.
Thank you, Judge.
Okay, so the judge said that you can file a subject matter jurisdiction at any point in time, but the meeting the threshold, he said that he hasn't made a decision on that. He'll make a decision on that. So now he needs to go through his second part of his motion. And again, I don't have the papers, so I don't know what he's arguing. So we're all in this blindly.
Your Honor, on May 14th, 2022, a 16-year-old Raul Valle, who sits next to me, attended a house party in Shelton, Connecticut. During that gathering,
Oh, it was in Shelton, Connecticut. I guess the courthouse is in Milford, Connecticut. Okay, just FYI, at the time of this incident, Raul Valle was only 16 years old. 16. And this was in 2022. Okay.
a violent confrontation erupted involving multiple individuals. Mr. Valle has consistently maintained that he was surrounded and feared for his life, and that his use of force was a lawful act of self-defense under Connecticut General Statute Section 53A-19. At trial, Mr. Valle testified that he felt terrified and surrounded. His self-defense claim was the central and dispositive defense theory presented to that jury.
Okay. Mr. Valle stated that he was surrounded. He feared for his life and that it was a lawful act and self-defense as to how and why he stabbed and unalived Mr. McGrath.
The state subsequently, after that party, charged Mr. Valle with murder under Connecticut General Statute 53A, 54AA in the death of James McGrath. They charged him with 3 counts of assault and first degree.
Hi, if you're joining me. Hi, Rye. We're talking about Raul Valle. You asked about it yesterday. We are going over the motion to dismiss, which was on June the 1st. So if you've already seen it, I'm sorry. I haven't seen it. So We are going over the motion to dismiss, which was June the 1st. And FYI, I looked up and he has not, the judge has not made a ruling yet. It is 30, we'll go 38 days, and he hasn't ruled yet. He said he was going to rule within a 90-day period. So we're going over the motion. I'm live on YouTube. If you want to join me over there, you can see us going through the hearing of the motion to dismiss from the defense. And remember, this is Raul Valle's second try at being tried for this account. And also, he's got a new attorney. So,
On the Connecticut General Statute 53A, 59A1, intentional first-degree assault for the stabbing of Ryan Hines, Thomas Connery Jr., and Faison Teal. The formal information also included lesser included offenses. After a full trial in Milford Superior Court on July 25th, the jury returned unanimous acquittals on murder and all 3 counts of intentional first-degree assault, the primary charges in the formal information. Now, Judge, the jury did deadlock on lesser included offenses, first-degree reckless manslaughter under section 53A, 55A3, as to McGrath, reckless first-degree assault, 53A, 59A3, as to Hines and Connery.
this defense attorney is reading the charges. He's reading the charges that Raul was set forth in his first trial versus his second trial. And I mean, it's kind of repetitive. The judge already knows this information, but he's reading it to him like he is schooling him, like they're in law L1 law class.
And reckless second-degree assault, 53A, 60, friend A, friend 3, as to Teal. Judge Sherry A. Murphy declared a mistrial on those deadlock counts and released Mr. Valle on the existing $2 million bond without new conditions. The state subsequently filed a pending amended information, which we just spoke about, which we object to, which mirrors precisely the 4 deadlock lesser counts. Now, the jury instructions, page 50, under self-defense, I'll get into in a second.
Okay, I don't know why the volume had just changed and
I'm not sure. I'm maybe my
the defense attorney has a microphone that's in front of his desk that he was reading off of. Now he's coming in front of the desk and he's getting ready to go give his PowerPoint presentation on this big television. And so he moved the microphone and the court clerk goes, ah, ah, ah. And he's like, what did I do? He needs to move the microphone so you can hear him.
Okay.
And then she's like, okay, you can have the microphone. Yes, please. We at home would like to hear you.
Motion to dismiss has now been filed on behalf of Raul Valle, and it is one of the more precise, disciplined constitutional filings you will see in a case like this.
Oh my God. You have got to hop on YouTube and you have to see this. Oh my goodness. They just, in his PowerPoint presentation, the first thing he brings up is a TikTok. I kid you not. It's someone's TikTok talking about so well, somebody has the motion about double jeopardy. Oh my God, it's someone's TikTok. I can't see whose TikTok it is. Oh my gosh. I'm sorry, I'm flabbergasted. This is a court hearing. This is a proceeding for the motion to dismiss. And it's like someone else's argument for his argument that he's arguing in front of the judge. I can't. This is hilarious. Here, Judge, I'm making an argument to you and oh my gosh. To me, this is like Elle Woods coming on and saying, well, Your Honor, here's a TikTok that's going to show you my case. Oh my gosh. Okay. Welcome to the new world of law where TikToks are part of your oral arguments. Okay, this is a first. I have to back this up because I just I can't. I just can't. Okay. Let's see what this TikTok has to say. And who is it from?
Motion to dismiss has now been filed on behalf of Raul Valle, and it is one of the more precise, disciplined constitutional filings you will see in a case like this. It does not hedge. It does not wander. It targets a single issue and builds around it with control. The state does not get to try this case again. This is not rhetoric. It is a structured legal argument that ties together double jeopardy, collateral estoppel, and Connecticut law in a way that forces the court to confront the same question from multiple angles. Start with what cannot be disputed. In July 2025, a jury returned not guilty verdicts on.
Okay, I can't. It's one of those TikToks where it's not a person's voice, it's like an AI voice. Like, so you're like, somebody typed it in and said, here's this AI voice, or perhaps maybe AI did it. Maybe it's an AI generated one that goes over the, oh my gosh. Okay. You join me on TikTok or join me on YouTube or Facebook because this is hilarious. I have never seen I've never seen. Hey, Judge, look at this TikTok that helps me bolster my argument. Oh my gosh. Now, I assume this isn't his filing. I'm assuming that they're getting this off of his motion that he filed. I got to get my hands on this motion. If you have the motion, let me know. If anybody has this motion, let me know, and I'll tell you how you can get it to me.
Murder. 3 counts of intentional first-degree assault. Those were the central charges. The same jury deadlocked on lesser counts framed as reckless conduct, and a mistrial was declared on those counts. The state then refiled those same lesser charges. The defense's position is straightforward. The Constitution does not allow the state to do that under these facts.
Now, on July 9, 2025, the jury spoke. On the left-hand side, you see unanimously acquitted on murder, that's McGrath, intentional manslaughter first, that's McGrath.
Okay. So he has this really cute PowerPoint presentation that talks about his case. And I'll post this on Facebook and on X later. And it says that what they unanimously acquitted him on and what they deadlocked him on. And they have 2 categories. It's very nicely laid out.
First, that's the Hines.
Listen, I love a great PowerPoint presentation. I hope you do as well.
Intentional assault first, that's the Connery. Intentional assault second, that's the Teal. On the right-hand side in red, the reckless manslaughter first, that's the McGrath, the jury deadlock. Reckless assault first, that's the Hines, the jury deadlock. Reckless assault first, that's Connery, the jury deadlock. Reckless assault second, the Teal, the jury deadlock.
Okay. I don't know about you, but when somebody has a PowerPoint presentation and they read off the PowerPoint presentation, does that irk you? It definitely irks me because I can read it. I can read for myself what your PowerPoint presentation says. Tell me something on there that's not on there that's going to bolster your claim, Mr. Crossland. Because if this is the way that this is going to go, this is going to be a very long next 30-some minutes.
Now, what the Constitution doesn't allow us to do is to go into the jury room and question as to why they deadlocked. The jury, we can imagine the jury may have thought that Mr. Valle's actions were not reckless. We can pontificate or guess or speculate as to what they were thinking, but the Constitution doesn't allow that. Same act, same night, same individuals. As we talked about the state's authority in Chestero, you must have something different, other elements. And Chestero breaks that down. But here we have the same act, the same night, same individuals, so we cannot have a new trial based on these facts. Now, framing the issue, the state is answering the wrong question. The state's question, does a hung jury permit retrial? That's what we just talked about. The answer is still yes. We have that all over the United States. But the real question is, did the acquittals necessarily decide justification? And the answer is yes.
Okay, here are some great legal questions. Does a hung jury permit a retrial? The answer is yes. And that's not in dispute. But did the acquittals necessarily decide justification? He's arguing yes, and that a case called Jaeger bars relitigation. So he's arguing a case with Jaeger that says they can't do it.
Yes, Jaeger bars litigation because
All right, Mr. Crossland, you're getting somewhere. I'm picking up what you're putting down. Let's go.
justification was used in the first, and if we were to go to trial this afternoon at 3 o'clock after lunch, my client would be saying that he was justified, he would be saying that he was defending himself, and the state would be arguing that same point because the burden is on the state then to prove that it wasn't justified. They failed to do so in the first trial, and they'll be trying to now try again to say they were justified. And that's exactly what the Constitution wants to avoid, that they get a retry to show that my client wasn't justified when they already got a chance, and that came back as that my client was justified based on the verdict. Now, on the Jaeger versus United States, 557 United States 110, the 2009 case, they quote, "The hung counts are what they call a non-event. The consideration of hung counts has no place in the issue preclusion analysis."
Okay. He's stating that hung counts are a non-event. The consideration of hung counts has no place in the issue preclusion analysis. This is what Jaeger has to say. Interesting.
The state cites Jaeger in their authority. Then they do the exact thing that Jaeger prohibits. So they cite it, and then they violate it.
How did they violate Jaeger?
They violate.
He's stating that the state violated Jaeger, and the judge, thank you, Judge. I was just going to ask that. How did they violate that?
Jaeger because Jaeger looks at whether there was issue preclusion. If the issue is justification and whether they had the burden of proving that my client was not justified, they failed to do that, then Jaeger said you can't now go back. And
How do you know the jury determined they failed to do that? Because I can tell you what Jaeger does say. Jaeger says the jury's deliberations are secret and not subject to outside examination. So you are performing outside examination right now, certainly suggesting, if not more, that the state somehow failed its burden to disprove justification. I need to know how you know that the jury actually discussed something.
that's
Ooh, great point. Okay. So the judge clarified and he said, Jaeger says that the jury is not subject to outside examination, meaning what happens in the jury room happens in the jury room. Once the jurors are excused from doing their duty, yeah, they can go talk to media, they can talk to other members and stuff, but it doesn't matter because what was said in the jury room is it. Once they put it on the verdict forms, that's it. You can go back and ask a juror XYZ and what did you do, etc. That's not going to change anything as to what transpired in the jury room. So he's saying to Mr. Crossland, how do you know that the jury said it was justified? Because he's claiming that Valle was justified. The state didn't talk about justification in their last trial, so they can't retry him. So the judge wants to know, how do you know what the jury did or did not say or deliberate? The answer is he doesn't. So, but we'll see what he has to say.
That's a good question. And Judge, what I do, yeah, exactly. What I do, I apply the reason and rationality basis that the Supreme Court also cites, and I'm going to get to that. There's reason and rationality that when the court gave the jury an instruction.
He says there's reason and rationality. Mr. Crossland, you don't know what the jury was thinking because you weren't in the room. You're not a fly on the wall. But he's going to cite some case law from the Supreme Court.
On page 50, the court says, if you find that the state has proved beyond a reasonable doubt each and every element of a crime to which self-defense, defense of others may apply, you must go on to consider whether or not the defendant acted in self-defense. So the jury had to look at each and every element of even the crimes that they put it on, as well as the other ones. And so I go on to highlight the reason.
But isn't there the possibility, again, I don't know, I'm never going to know. Isn't there the possibility that when the jury deliberated, they never reached the issue of self-defense because they determined the state did not carry its burden of proving intentional conduct beyond a reasonable doubt?
Oh my gosh, this judge is great. I love this judge. He just said, okay, well, how do you know what the jury considered? Do you even know if the jury considered whether or not this was self-defense? Maybe they didn't get to that argument because the state didn't prove XYZ, so they only got to XYZ elements, and therefore they didn't even get into that. You don't know what the jury deliberated because you weren't in the room, and you're never going to know. Well, you might know afterwards, but it doesn't matter because once the jury's out, that's it. Oh, interesting arguments.
And that's why they issued acquittal. Isn't that possible?
Well, as they always say, anything's possible. What's probable is under reasonable rationale.
Anything's possible. Anything's probable, right?
Here, and you see a person who's wielding a knife at someone, that the only intent they could have is in defending themselves is to cause bodily harm. And if you do so, you can't say that the person now who's wielding the knife in defense of themselves, who brought about these consequences, didn't have that intent.
But in the charge conference, did they discuss a reason and rationality test?
In the charge conference?
Yeah. That's what you're using as the criteria for the issue that I've raised under Yeager, which is the outside examination of jury deliberation.
Okay, so the judge asked him, did they perform a reason and rationality test? And I'm assuming he means the state. And again, they're talking about the jury.
So it's not a criteria. I think what the Supreme Court looks at is they say that you can't look at the draconian, I think the word is, I forget, I'll get to in a second, but you can't look at a draconian, hyper-technical analysis and say that, oh, well, the jury may not have self-defense, but, man, and they talk about how you apply that. So I think you have to apply that as a whole. And so obviously the idea is if the person says, I intended to do this, right? I intended to do this, and I did it because of this, and they apply that to the elements, then we get to these hung charges. And as you said, we can't know what they're thinking.
But why are we applying anything to the jury deliberations? The case you cited, Yeager versus United States, 557 U.S. 110, said the jury's deliberations are secret and not subject to outside examination. That's not, you're arguing somehow that the jury had to have found.
Okay, so the judge is calling BS on this attorney. It's like, okay, you're arguing Yeager, which are saying that the statements made outside of the jury room are, not subject to what transpired to their decision that was made in the courtroom, right? And the judge is saying that Mr. Crossland is arguing that, again, Mr. Crossland is going into the minds of the jurors and stating that he believes that they did XYZ, but he doesn't know. And so the judge is like, how can you argue this if you don't know what the jurors did? Oh, it's so good. So good. But I like this because this is more like an appellate style where the defense attorney is giving out what they feel, and then the judge is questioning them on what cases and stuff that they are citing. So if you're just joining me, we're talking about the Raul Valle case. Raul Valle is being charged again for the lesser crimes in his case, and his attorney is filing a motion to dismiss. This is the motion to dismiss hearing. He's arguing in front of the judge. If you want to join me, I'm also live on YouTube. If you want to hop over there, you can see this along with me.
Mr. Valle's conduct was excused because of the justification defense, as you put it, or self-defense. How do we make that leap if we're not allowed to conduct outside examination of their verdict?
With respect, and respect.
Right, he's saying, the judge said, how can we make the leap if we cannot talk to the jurors outside of the presence of the court case happening? I'm kind of paraphrasing. Let's see what Mr. Crossland has to say.
What I said was that if we are going, none of us can go into that room and guess what they said. I said they could have very well.
We can't even guess what they said now.
Right.
I said they could have very well said.
You can't guess what they said.
They could very well said that they were self-defense. We can't go in and guess that. And so I think the jury verdict stands, and the question is to a court of competent jurisdiction, looking at the hung charges, the court has to then make a determination, how do we proceed? Can this prosecution now prosecute again? And that's where the legal analysis comes in. And so that's the rub. So you're right, we can't guess, but we have to do
I
something.
agree with you on that. I do agree with you on that, sir. But if you and I do have an agreement on that, I'm not sure Jaeger is the proper authority for it, because Jaeger is very clear. Again,
Excuse me, Mr. Crossland, I'm going to help you do your job here. Jaeger may not be the case that you want to cite in your argument. Judge, are you going to tell him what is?
jury's deliberations or verdicts.
And
That's
Judge,
conjecture, guesswork. That is about as sacred as it gets on the criminal law side of our documents.
and 100%, I was before the appellate court a couple months ago, three hot bench, and I can tell you that I think we have to look as intellects, we have to look at the total picture and decide how do we get to where I'm arguing we should be. And if not, obviously the appellate court looks at that and say. But I think the Supreme Court precedents that say this case cannot be tried, even above and beyond Jaeger.
Okay, so Mr. Crossland, I think what you're trying to say is, Your Honor, this is just an opening. I'm painting a picture here for you, and this is just my opening. And Mr. Crossland, your opening's not going so well.
So look at going beyond Jaeger. Look at Chestero. Chestero was, I think, cited in the staged response. That's a 197 Federal Third, a 1999 case. That's the state's lead case. That's the case they relied on as their lead authority. That's their case, and it's their case, it's their test, and we still win that analysis. Chestero's rule. We try.
Okay. I'm not sure what he's saying when he's saying their case. All right, we'll go back to this. All right. So they're saying that the prosecution is saying that they used Chestero, which was a case, and this is what his PowerPoint presentation says. Retrial is barred where the acquittal necessarily determined in the defendant's favor an issue that would be an element of the offense at retrial. Their case, their test, we win. Okay, this is what it says. In Chestero, retrial allowed. Acquittal turned on the weapon/injury element only. It decided nothing about the lesser elements. In this case, retrial barred. Acquittals necessarily decided justification. The identical fact the state must disprove on every reckless count. Okay, if you're going that route, if you've gone that route, he keeps going back to justification. That justification wasn't argued in the first trial, and yet it should be dismissed because they didn't do that. That's what Mr. Crossland is saying. I don't think this is going to go well for Mr. Crossland. I already see this, and we are 22 minutes in. All right, let's continue. I don't want to make a prejudgment just yet.
And we still win that analysis. Chestero's rule. Retrial is barred where the acquittal necessarily determined in the defendant's favor an issue that would be an element of the offense at retrial. And that's very clear. And that's their case, and the Supreme Court is very clear with that. In Chestero, a retrial was allowed. And I think that's what the state got a little intoxicated on, because they saw that in Chestero it was allowed. But it's not just allowed blanket. It was allowed in Chestero. The acquittal turned on the weapon/injury element only. It decided nothing about the lesser elements. And that's why in Chestero, the court allowed them to have retrial. In this case, the retrial is barred. The acquittals necessarily decided justification. The identical fact the state must disprove on every reckless count. So if we move forward, unlike Chestero, the state's going to then be faced again whether this was justified. And that's why it's barred.
But do they even get to it? Do they reach that? The jury instruction.
Okay, so the judge said, again, they're going back to the jury. So I think Wow. So I think that this is he's continuing to say that, Your Honor, look, the jurors who are the finders of facts already ruled on this based upon that's exactly what he's saying. Mr. Crossland is saying, hey, listen, the jurors in the other case found that he was acquitted of these charges. They were hung on these charges. They've already gone through the deliberations and everything. And so therefore, he can't be retried. And the judge keeps going back and saying, how do you know what the jurors said? You don't know what the jurors discussed in the jury room, and you're not going to know. So this is not going well for Mr. Crossland. This is where he's going. This isn't going well.
State and instruct that you first have to establish that the state has carried its burden beyond a reasonable doubt of all the elements of the crime. They make that finding, then they can pivot over to justifiable self-defense. If they do not find that the state has carried its burden beyond a reasonable doubt, do they even get to self-defense?
Page 51 of Judge Murphy's instructions states quite clearly under the state's burden, when evidence of self-defense / defense of others is introduced at trial, the state, in order to obtain a conviction, must prove beyond a reasonable doubt both elements of the crime charged and that the defendant did not act in self-defense. It goes on to say on page 51, if the state fails to prove beyond a reasonable doubt that the defendant did not act in self-defense or defense of others, you must find the defendant not guilty, despite the fact that you have found the elements of the charged crime proved beyond a reasonable doubt. So I think when you apply the
Okay, so Mr. Crossland brings up the jury instructions. And jury instructions can be very confusing. So he read them. I'm not going to reread them, but that's what he's arguing. He's arguing, hey, listen, the prosecution said you have to state whether or not this was self-defense, whether or not it was justified, and by doing so, XYZ. Therefore, if they said not guilty, then he's not guilty. You can't retry him again. That's what Crossland's defense is.
reason and rationality approach, the jury goes back. They heard the entire case. They heard self-defense. They looked at all the elements of the crime charge. So if somebody's charged with murder, you cannot be found not guilty of intentionally doing something, and I'll go into this, because you intentionally stabbed someone. So you can't be found not guilty of you can't have a consistent verdict where they say you're not guilty of intentionally doing something, but you're guilty of recklessly doing it. That doesn't sound in logic. So if you intentionally do something and they say not guilty, we can only conclude that when they applied the elements, justification wasn't disproved, I should say, by the state. So they found not guilty of murder. Then they can't come back and say you're not guilty of intentionally doing something, but you're guilty of recklessly doing it.
What if they found that the state hasn't carried its burden in the first part? We don't know if they did or not.
And
we're never going to know.
And there lies the problem. You have to look at the state of the record.
Okay, so Mr. Crossland is saying if he was found not guilty of intentionally doing anything, and now the state wants to charge him for recklessly doing something, and Crossland is saying you can't have a bite at both of the apples when one was found not guilty and now you're charging him against something else. And then again, the judge goes back and says, well, we don't know what the jury deliberated.
And again, the court may conclude differently, but I'm saying the state of the record shows that he intentionally did this. All through the trial, he said, I did this.
No, the state of the record shows acquittal, 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 acquittal. That's the state of the record.
That's the state of the verdict. But the state of the record is what defense that Mr. Valle say in that trial. He says, I did this intentionally because of this reason. And then we have the acquittals.
But what if the jury did not find merit in that? Or what if they did? We don't know. How are you supposed to know that? We don't sit as a 13th juror. You, Mr. Durso, or myself.
Who's the 13th juror?
And the judge can't sit in 13th juror under certain case law.
Good luck in that in federal court, but we're here in the local superior court. So
And so Judge, that's my position, obviously, that you can't do something intentionally and be liable for recklessly. You can't be acquitted for doing it intentionally, but say, oh, we can hold you liable
That's a
for
whole
recklessly.
different argument that I'm confident when the state has its opportunity. I'm not gonna put words in Mr. Gerso's mouth because I don't have to, but I assume somewhere we're gonna hear some argument on the difference between reckless conduct and intentional conduct.
Yes, sir. So,
Okay, Mr. Crossland is a very experienced attorney. He's done appellate cases and he's also been in federal court. And he just argued that he made a federal ruling case for the 13th juror. And the judge says, "You're not in federal court. You're in my court. So you're in a different jurisdiction, Mr. Crossland. You can't bring up what you did there here." Besides that, it doesn't apply here. You can't be the 13th juror because you weren't in the room. Oh boy, I think we're going to see a pattern here.
anticipating this type of colloquy, I decided to take something, one of the charges that I think crystallizes this more clearly.
I really like him. He says, "I want to take one of these charges that crystallizes what's going on." And he's talking about the Teal acquittal. So Faison Teal. So he has Faison Teal, the intentional assault, second degree. The stabbings were never contested. Mr. Valle did not dispute he stabbed Teal with a knife. Intent to cause physical injury by stabbing cannot be rationally denied. No jury finds a person who stabbed another with a knife lacked intent to cause physical injury. Well, again, you're saying what the jury said, and you don't know that. You're saying no jury. That's a blanket statement. Oh my goodness. Oh, I appreciate Mr. Crossland so much. He's really trying. And then he's saying, therefore, the only rational basis for this acquittal is justification. Okay, let's see what the judge has to say.
And I think that same teal, I call it the teal sponge.
I don't think this is
You
going to
can take
fly.
that teal sponge and use it. So using the teal sponge, the dispositive anchor looks at count 4. Count 4 was the teal acquittal. Intentional assault second, 53A 60, parent A, parent 2. Elements: intent to cause physical injury, you just talked about that. Number 2, cause injury to Teal, yes, undisputed. And 3, by a dangerous instrument, right? Those are the elements that Kulian put out in order to get to what they're trying to go. The stabbings were never contested. Mr. Valle did not dispute he stabbed Teal with a knife. Number 1, clearly undisputed. Using the same Teal sponge, we go to number 2. Intent to cause physical injury by stabbing cannot be rationally denied.
He's reading this to the
Stab
judge.
someone with a knife, intent to cause injury. Question is whether it's justified, and that can't be rationally denied.
No.
No jury finds a person who stabs another with a knife lacked the intent to cause physical injury. That's just illogical.
What if, and this is not the fact,
I knew it. So he's reading what I just read to you. And again, he says no jury. And I don't like that language. When you say no jury, you are making assumptions there. So the judge, after he reads that statement, the judge jumps in. So let's hear what the judge has to say.
as I understand it, at least at this juncture. What if a person was involved in an assault using a knife, but was entirely intoxicated? Now, I'm not saying that that's not the valid case. What if that person wielding the knife was entirely intoxicated, and tox results prove that, which would strip that person of the intent? You're saying that a jury can't find that?
Oh, okay, so I can speak to that because I've had cases like this. So
Yeah.
Okay, so the judge gave him a scenario, right? He said, all right, I know that this didn't happen here, but what if there was a knife assault and the person was intoxicated and the tox report came back and said that the person was intoxicated. And Mr. Crossland is great. He's like, oh, Your Honor, I can answer that because I had a case like that. Let's see what Mr. Crossland has to say.
Right.
I'm reading where it says, no jury finds a person who
Right,
stabs
no
another with a
jury.
knife lacked intent. I think the example I just gave you might give the jury an opportunity to say that person lacked the intent because of the intoxication.
as a jurist, that's a proper analogy to make. However, as jurists as well, we know that intoxication may negate an intent, right? Because it goes to mental state.
But you're saying that can never happen.
Intoxication may negate intent.
It doesn't say some juries. It doesn't say the Valley jury. It says no.
I called it.
No jury in my state.
The judge, it's the language. You have to be careful about the precise language that you use. You cannot say that. So the judge called him on it. He's like, you said no jury. And now you're saying some jury. You can't be talking out both sides of your mouth here, Mr. Crossland.
In my state of mind, Judge. So obviously, I'm trying to respond to as more as succinct as possible. And so, in this case, my position is quite clear that the stabbings were never contested in this case, right?
He's saying, Your Honor, let's just stick to this case. This case, not your intoxicated case that you're hypothetically talking about. This case.
We know that. The intent to cause physical injury by stabbing cannot be rationally denied. Mr. Valle stated why he stabbed, and therefore this jury cannot find that he lacked intent because he said he intended. If that makes it a little easier.
It does, but what if, let's go to Valley now, forget my example about intoxication. What if the jury, after full and fair deliberation, found that Mr. Valle did not have the intent? And they acquitted him on that reason. I don't know if they did or not, I'll never know. But what if they did have that discussion and arrived at that conclusion? And you're saying they can't, but the only rational basis based on reason and rationality, which candidly I still don't know what that means yet, but that's what you're saying. That the only verdict they could have arrived at was based upon the state's failure to disprove self-defense, right? Because I read and I agree with you. Self-defense is a valid defense to intentional conduct. Self-defense is a valid defense to reckless conduct. You wrote that. I agree with you. But what?
Okay, so the judge said that he understands that the state failed to disprove self-defense. But again, we're talking about a motion to dismiss here. We're talking about whether or not Raul Valle's case will be dismissed based upon what Mr. Crossland is arguing. And Mr. Crossland, I'm sorry, but you're arguing two sides of a stick. A pokey end and a non-pokey end, right? I'm being facetious here. But like you're trying to poke the bear to get the case dismissed. And at the other end, you have a blunt side that you're trying to poke to deflate things. And it's not going to work. I don't think it's going to work. If you're just joining me, we're talking about the Raul Valle case. Raul Valle is being charged for lesser crimes. The state is going for a second round. And Raul Valle has a new attorney, Mr. Crossland. And on June the 1st, they had a motion to dismiss, and we're going over that right now. We are live on YouTube if you want to join me over there. It's very interesting, and these are legalese, hence the name. These are legalese issues, right? We're talking a lot of legal speak. We're talking about different cases and how you can apply these cases to what you're arguing. So he's arguing several different cases in front of this judge, and this judge is doing sort of what I call an appellate style, where you raise a question about a current case, and then the judge just asks you questions. And the judge is asking questions, and they keep going back to what did the jury decide? And unfortunately, this is not going well for Mr. Crossland because he keeps trying to second guess what the jury was deliberating in the room. And he's saying, but therefore causation, if the jury discussed this, then they acquitted him on this. But you don't know what the jury was thinking. You don't know what the jury was deliberating unless you're a juror in the room. And again, once the jury hands over the slip of paper to the judge that said that they either acquit or they have a mistrial, That's it. It's done. You cannot recall the jury back and ask them questions. We saw that in the Karen Reed case, right? Karen Reed case, there was a mistrial, and because apparently they might not have understood what the form was. Remember, the form was very confusing. They brought it all the way up to the Supreme Court. The Supreme Court said, nope. Once the jury has made their decision, that decision is final. You're not going to go back and recall that jury. It's called the sanctity of the jury. It's sacred. You cannot go disturb that. I call it like a grave. You can't go disturb that grave because it is sealed. That's it. And Mr. Crossland is like, yeah, you're judge. No, you judge. They delivered XYZ.
What you're saying, and I have highlighted in several places, the state failed to disprove that Mr. Valle's use of force was justified pursuant to Connecticut General Statutes 53A19. And because self-defense is a valid self-defense through reckless conduct as well, the state cannot prosecute Mr. Valle any further. Isn't that your argument? Because that's not the case.
Okay, so the judge is saying, listen, is this your argument that the state disproved that Valle was justified, so therefore he can't be retried again? That's what the judge is trying to say. Is this the bare bones of your argument?
One of your most recent memorandum.
That's my response, yes. And so,
Crossland says yes.
The court's going to say again, and I would agree again, that obviously you can't go in the minds of an individual, such as the jury, to say exactly what they were exactly thinking, where they went.
Crossland says, "Oh, you're right, you're right, Your Honor. We can't go back into the minds of the jury. Yet you want to. Yet you want to go back into the minds of the jurors. That's what you're arguing. Oh, come on, Mr. Crossland. Let's move on, because now you're repeating yourself over and over again, and it's not working."
But when we look at mens rea, and in all criminal cases, we have a mens rea and an actus rea. We never really get a contract.
Okay. Do you guys remember in Legally Blonde when Elle was up there and she's like, Your Honor, it's mens rea, and you have to go into the mind of the person who committed. He's saying that. He's legally blonding the judge right now. I'm serious. It's a 1L law class.
Even in conspiracy cases, it says what the agreement was.
Oh,
we look at the behavior, and then we kind of infer. So if the jury has Mr. Valle at trial saying, I did this intentionally, then when you use that, and you're rational, then you say, if he says I did it intentionally, then...
I can't believe this. If this is the way that this is going, we still have 30 more minutes left. If this is the way that this is going, I can't believe that this judge has waited 38 days to make a ruling. Like, he could have just ruled from the bench right there.
You can't say he lacked intent because he told him he told him it was intentionally.
I wasn't in the trial room. I don't know if he testified.
The judge says, I wasn't in the trial room. I don't know.
If he did or not. And even if he had, I'll give it to you, even if he had testified in that manner, I do not know how the jury processed that testimony.
He doesn't know how the jury processed the testimony.
We can get down that road, but that still doesn't give the state of Connecticut an opportunity to violate the Constitution and try someone again on the same elements. But good question in terms of whether, in fact, we can go inside their mind. I'm applying the rational basis test, but you're applying.
Good phrase by you, though, the same elements. Yeah, we'll see.
I love this judge. This judge is incredible.
Nothing but justification. That necessary decided fact is the identical issue the state must relitigate.
Okay, Teal's acquittal rests on nothing but justification. That necessarily decided fact is the identical issue the state must relitigate on the reckless count. Okay, so let's go. Your motion to dismiss is denied, and they're going to try you again.
On the reckless count, and Ash versus Swenson, 397 is a United States Supreme Court case at page 436, 1970 case that speaks about that. So you cannot, on the identical issue, go and relitigate and get a second chance and repackage.
But again, that's, if we can go back to that other slide,
He's saying you can't relitigate this.
this captures the court's concern in one sentence, and it was the sentence that Mr. Crossman has used in his presentation. The Teal acquittal rests on nothing but justification. A certain sentence that eliminates any other possibility of acquittal. And I just don't know how we can make that.
So in response to that, Judge, I would
Oh, this judge is fabulous. Okay, so in a presentation that Mr. Crossland is doing, he's saying the Teal acquittal rests on nothing but justification. He's like, I don't know how you get there, Mr. Crossland. Again, we're going back to what did the jury say? You don't know what the jury said. You don't know what the jury deliberated. Oh, this judge is amazing.
say that if the court is at a dead stop in terms of not agreeing with this conclusion that I'm making based on Ash.
Well, Yeager says I can't.
And Ash says that obviously.
Right. Yeager says you can't go back and ask the jury.
That the state's now trying to be litigated identical to the issue below, they can't do it. The issue below, even moving away from what we think that we don't know. The jury might have been smack on with me, but we don't know, a secret. But the issue below, you know, is that this man was in danger, and he articulated that, and that's why he acted in response to that danger, because he could have been stabbed, shot, etc.
He's arguing both sides.
In self-defense, and the jury said not guilty, right? And so now I guess we're stuck here in this court again saying, well, why did they say not guilty? And
I'm not,
and we don't
I'm
know.
not concerned about that.
You
I
say
just
they-
know that the man received acquittals, and we do not search, pry, probe.
Right. The judge is saying the jury has spoken. They served you an acquittal. That's it. That's all that I can do. I can't go back and I can't question them. Again, we're talking about the same thing over and over again. We can't go back to the jury and ask them if they, in their deliberations, did they discuss XYZ to come up with the conclusion of here. We can't discuss whether or not he was justified. We don't know what the jury was thinking. So, Mr. Crossland, no.
Guess into how they arrived at that decision.
Right, and so I think that we look at the record and say that he was saying that he was defending himself. The state before an outlaw has the burden to prove that he was not justified. They failed to carry that burden. How do I know they failed to carry that burden? It's because the jury came back with an acquittal, not guilty, on an intentional murder, an intentional act. He said, I did this. And any jury is going to say, you did this. And maybe there's some other reason. We just like your suit that day. But rationally, is he said, I intend to do it. The question is, were you justified in doing it? Not because you had a nice suit on. And if you don't kill someone, and the jury says, you can go home. But we don't know why.
Mr. Crossland is arguing whether it was a justified act or an intentional act. And the jury acquitted him on the intentional act. And now he's saying, Mr. Crossland, again, talking on both sides of his mouth, saying it was justified. And the state didn't disprove that. So you can't retry him again because now you're saying it's a justified act and you didn't encounter that in the first trial. So it's double jeopardy. That's kind of like, that's where we're getting to. That's what Mr. Crossland's trying to argue. And the judge is not buying any of it.
It's because the law says, and the jury section says, that they have to prove that he was not justified. And if they say...
No, they have to prove the elements of intentional conduct, is what they have to do.
Well, that's if they want to get a guilty verdict beyond reasonable doubt. But if they're saying that the defense of self-defense is not, they disagree with it, they have to prove that he was not justified. That's their burden. It's in the law, and that's their burden to prove. And if they fail to do so, that lets the jury say, okay, they failed to do that, and therefore we're going to quit. But again, we don't know nuances, but that's rational.
We don't know the nuances, but it's rational, is what Mr. Crossland just said.
At page 369. That's a
Okay, so his next PowerPoint presentation, he said, the state cited the losing side. The state cites on page 410, jurors could not have considered the lesser offenses if they acquitted on the basis of self-defense. And he's saying that the defendant's appellant losing argument the Espinal court rejected it. ESPINAL must be another court case. The court held that the instructions were adequate and upheld the exact same elements first/self-defense, second structure as Judge Murphy's Valle charge. Oh my goodness. So if you're just joining me, we're going over the Raul Valle case. Raul Valle was tried once, acquitted on some charges. There was a mistrial on some of his other charges, the lesser included. He's being tried again on the lesser included alone. His lawyer, Mr. Crossland, is arguing that this is double jeopardy and trying to argue in front of the court. And it's a great argument, but it's going nowhere.
Very, very recent case. The state cited the losing side. The state cites page 410. Juries could not have considered the lesser offenses if they acquitted on the basis of self-defense. That's what the state says. That is the defendant's appellant's losing argument. The Espinal court rejected it. The court held the instructions were adequate and upheld the exact same elements first/self-defense second structure as the Judge Murphy's Valle charge. So when you look at Espinal, I think the state gains no position even in Espinal. McElrath versus Georgia, 601 U.S. 87. That's a 2024 case on our doorsteps, very recent. Once rendered, a jury's verdict of acquittal is invalid. You cannot touch it. At page 94. Cases prohibit any speculation about the reasons for a jury's verdict, even when there are specific jury findings that provide a factual basis for such speculation. At 97.
Okay, so his next slide says, once rendered, a jury's verdict of an acquittal is invalid. Cases prohibit any speculation about the reasons for a jury's verdict, even when there are specific jury findings that provide a factual basis for such a speculation. You're arguing out of both sides of your mouth, Mr. Cortland. Oh, this isn't going to go well.
Jury findings that provide a factual basis for such speculation. At 97. A hung count, Yeager says, is a non-event. Provides even less basis. The state's inference is doubly forbidden. Now, I think that the idea is that we don't want to go into jury rooms. We want to question their verdicts. We don't want to even double think. And under this McGrath,
we don't want to double think what a jury says, yet you are doing that exact thing, Mr. Crossland.
United States Supreme Court case that says once rendered, the jury's verdict of acquittal is inviolate. Cannot question it.
But wasn't McElrath, the issue in McElrath was a jury determined that the defendant was not guilty by reason of insanity. And the issue was, can the state retry him based on that initial finding that he did not have the mental ability to go to trial? Though that's not even close to what we have here.
I'm not sure how course-martial on that. If the person,
I'll read right from McElrath, one sentence. For double jeopardy purposes, a jury's determination that a defendant is not guilty by reason of insanity is a conclusion that criminal culpability had not been established, just as much as any other form of acquittal. So McElrath had to deal with a defendant being found not guilty by reason of insanity.
Okay, so Mr. Crossland stated a case, I think it's called McElran, that states that the defendant was found not guilty by reasonable, he was mentally incapacitated. And then they asked whether or not the person can be retried. And I think the end result was that no, because once he was found mentally didn't have the mental capacity, and therefore he was found not guilty, that doesn't apply here because you're not claiming that Mr. Valle has any mental deficiencies. So, why is this in your argument? The judge is calling him out on this. If you're joining me, we're just going over the Raul Valle case. The defense wants this case dismissed for double jeopardy, and he's not winning.
And the state attempting to retry that defendant, which McCower said you can't do. But insanity was never part of the Valley trial.
Yeah, but you see, I mean, I'll just address it. You see the difference there. Obviously, when you're found not guilty by reason of mental insanity, NGI, not guilty of mental insanity, the issue still believes that, well, if he wasn't mentally insane, his behavior might have been criminally liable. But this is not mitigated because it's actually exonerates the person. But I think there's a distinction here. But the idea is that once the verdict is rendered, you can't touch it. Here, I don't think the state's trying to touch the verdict of acquittal, but they're trying to now retry the lesser charges, and they have to meet a certain verdict in order to
Based on manifest necessity, which does not trigger double jeopardy or collateral estoppel.
All right, Manifest Destiny has entered the chat. Okay. Oh my goodness. All right. Manifest destiny is not a formal legal doctrine, but rather a 19th century political ideal or ideology that courts have historically relied upon. A modern court's active critique when ruling on Native American land rights, waters, and federal territories. This is what this says. It codifies the spirit of manifest destiny into American law, allowing the federal government to legally overwrite indigenous land titles. This is what this says. I'm trying to get it to give us a all right, it's not giving me what I need, but basically the judge just said, Mr. Crossland is saying, okay, they're charging him on the lesser charges again. They can't do that. And then the judge said, well, if it's manifest destiny, which means they can override that.
Yeah, so I think it's a distinction. We do have collateral estoppel, and we do have double jeopardy. Collateral estoppel is a component of double jeopardy, and that's what we're saying. Is the issue precluded? It's the same issue. Collateral estoppel is inside double jeopardy. It's a part of the makeup. It's in the soup.
Oh my gosh.
You go to State versus Williams, 352 Con 104. That's a 2025.
Okay, hang on. He just brought up double jeopardy and something else.
And that's what we're saying. Collateral estoppel is a component.
Collateral estoppel is a component inside double jeopardy. Is Mr. Crossland just like he's just throwing the spaghetti at the wall and seeing what sticks? It's just so okay. Also known as issue preclusion is a legal doctrine that prevents a party from relitigating an issue that has already been decided in a previous lawsuit. He's saying once the court makes a final ruling on a specific factual or legal issue, the exact issue cannot be raised or contested again. Okay.
Double jeopardy. And that's what we're saying. Is the issue precluded? It's the same issue. Collateral estoppel is inside double jeopardy. It's a part of the makeup. It's in the soup. You You go to State versus Williams, 352 Con 104. That's a 2025 Connecticut Supreme Court case. Self-defense bars.
So it said, here's a real world example that Darnell Crossland is using it. Obviously, they know that that's what I'm looking up. He's saying that the defense claimed that because in 2025, the jury acquitted Valle of intentional murder, that he had already decided the issue that Valle acted in a legitimate self-defense. Therefore, under collateral estoppel, the state should not be legally, the state should be legally blocked from trying to relitigate Valle's actions in a second trial. I don't think this judge is buying it.
The reckless charges. And that's what we talked about when I opened up, when we started talking this morning. Self-defense absolutely bars any coming back on reckless. And obviously that's what the state's trying to do. They're coming back on reckless charge. 53A-119, justification is a complete defense to manslaughter and assault. The state bears the burden of disproving it beyond reasonable doubt. In Williams applied the rule even where the victim was an innocent bystander, not involved in the confrontation. And I read this, looked at this, and just being rational. And Williams, the person was an innocent bystander. And as they say in some fancy term at fortiori, if the defense protects a defendant who accidentally harms a bystander, it certainly must apply with even greater force where the alleged victim were the very persons Mr. Valle was defending himself from. And so again, just being pragmatic, you know, in a self-defense claim where an innocent bystander is killed, it still applies. In this particular case, Mr. Valle is saying, I'm defending myself from the same people who are attacking me, and it should apply even with greater force. And
the principal issue in Williams was whether the trial court made a mistake in not giving the jury an instruction at all on self-defense. That was State versus Williams. In that case, the trial court gave no instruction at all in connection with self-defense. And you're asking.
Okay, so then he cited another case, which is Williams. And in that case, in Williams, it stated that there was not a jury instruction about self-defense. And so now the judge is saying, are you asking him to cite with authority
That appeal,
that appeal is what he's arguing today?
The self-defense instruction. In fact, you read it into the record this morning.
correct. And so what I'm saying to you, even in Williams, absolutely.
And then he said, you already stated for the record that Raul Valle used self-defense in his first case. So you've already read that into the record. So again, we're talking out both sides of our mouth here.
You pull a case, you pull it for a reason. And Williams didn't talk about 53A-19. And justification is a complete defense of manslaughter. And as I'm stating, that self-defense bars the reckless charges.
But the problem in Williams is they never instructed the jury on 53A-19.
Okay, so he's saying in Williams, as the case that he's trying to cite, that the problem wasn't about whether or not self-defense or justification was in there. It's just that they didn't instruct the jury. But that's not the problem with the first case. Okay.
And you want me to use Williams as authority for your position? The trial court in this case issued an instruction.
Judge isn't buying this.
Over and over.
Judge isn't like, you want me to use this?
I agree with that 100%. My only point in giving more than less, obviously you don't have to rely on Williams. A court relies on what they might feel persuasive and disregards the rest. And sometimes dissent.
Okay, Mr. Crossland used this analogy on his PowerPoint presentation. It says a fortiori. And it says it's a Latin league term that translates to with stronger reason. A legal arguments. It is used to state that if one lesser fact is true, then a second greater fact must logically and automatically be true. Is that like a squared plus b squared equals c squared? If you can prove the harder thing, the easier thing is proven a fortiori. Okay. The argument typically flows from stronger premise to an inevitable conclusion. Premise A, it is illegal to drive a vehicle over 100 miles per hour on a city street. Premise B, if driving 100 miles per hour is illegal, then driving 150 miles per hour on the same street is a 40 is also illegal. Oh, that is not a forte. The Williams case is not a forte. So he's saying, well, since they did it here, it's a forte here. But you're not arguing that the jury instructions were not incorrect in the first case. You're not arguing jury instructions. All right, let's continue.
In many cases, we'll take something that may not seem persuasive and argue an extrapolation from that. So I think that it's important for the court to look at. The self-defense comes up again, and that it's a complete bar, even for reckless charges. Summary. The three independent bars to retrial.
Okay, we're to his summary. We still have a ways to go. It says, oh, he's still using, in his summary, he's using the cases that he cited that the judge shot him down for. Oh, goodness. Okay, this isn't going to go well.
One of them requires a dismissal. All three demanded. Yeager, with the state's recent case of Chestero, the state cannot use the deadlock to infer no justification finding. Chestero's own test, their lead case, requires dismissal because justification is a necessary fact that acquittal was decided. Count 4, using Ash, the Teal acquittal on intentional assault second can rest on nothing but justification. Intent to cause physical injury by stabbing is not rationally deniable. The Ash standard is satisfied. And McElrath, the acquittals are invalid. Speculation is forbidden, even when specific jury findings, a hung count is a non-event. Provides far less. The inference is doubly prohibited. Relief requested. I think the court, when you look at the state of the record, and I have the transcript, of course, you get the transcript. This young man was 16 years old at the time, was fighting for his life, and he stands here years later, still under the same prosecution. And now the state is attempting to repackage.
I love Mr. Crossland. He said the state is attempting to repackage. No, the state said that, okay, we tried this first time on these charges and we weren't successful, so we're going to retry him on the lesser included, which they have a right to do. It's not double jeopardy. Double jeopardy is, hey, you killed someone, therefore you're found not guilty, and we're going to retry you again for the same crime twice. That's double jeopardy. He's not. He's being charged on the lesser included. Yes, he was charged in the first one. They didn't make a decision on that, so they get to retry him again. That's the law, Mr. Crossland.
The lesser included, and then have the same trial again. I beg the court to apply the idea that if we would try this case at 3 o'clock this afternoon, the exact same victims will be brought up, the exact same defense will be brought up, the exact same burden that the state had in the first trial will be used, and it'll be Groundhog's Day all over again, which the Constitution.
Okay, that's where the Groundhog's Day came in. He's like, Your Honor, if we tried this case again at 3 o'clock, we're going to have the same witnesses. They're going to say the same thing over and over again. It's going to be Groundhog Day all over again. If we retry this case right now, today at 3 p.m., they're going to say the same things, and therefore it's double jeopardy. I like your arguments, Mr. Crossland, but it's not factual.
Double jeopardy, collateral estoppel, Ash, Yeager, McElrath, the acquittals necessarily decided justification, an essential element to every pending case. Now, of course, if the court were to take another approach at this, the court will be inclined to have a whole evidentiary hearing on this. And as the court stated earlier, the court wasn't there. Maybe the court doesn't know the record that's clear. But if we would go beyond anything but dismissing this attempt to retry, the court would have to have that hearing. As I mentioned, it's been 4 years under this prosecution, 4 unanimous acquittals. Mr. Valle was a juvenile at the time of the incident, and these are the compelling circumstances the statute exists to address. Lastly, I point Ash, again, Ash versus Swenson, 397, the United States case.
Okay, he keeps going over what he just argued. He went over like summation, all of the cases that he went over and why he should go ahead and oh, he just oh my gosh, he went over oh goodness. He just went over collateral estoppel, what I just said. The rule of collateral estoppel in criminal cases is not to be applied with a hyper-technical and archaic approach of the 19th century pleading book, but with realism and rationality. Okay, that was from a 1970 case. Let me know in the comments what you think. Do you think that Raul Valle should get a new trial? Or sorry, do you think Raul Valle's case should be dismissed based upon what Mr. Crossland is arguing?
I know the court said earlier that I think, I don't want to misquote the court, that you don't really know what that means or you're grappling with that. This is a quote from Ash versus Swenson. And again, the rule of collateral estoppel, which I said is inside double jeopardy, in criminal cases are not to be applied with a hyper-technical and archaic approach of the 19th century pleading book, but with realism and rationality. And so when you look at this entire case, Judge, I think the jury spoke. Judge Murphy did a great job with
saying the jury spoke.
She always does. And she did a great job putting together its jury instructions. And she did a great job with Mr. Mr. Valle, and Mr. Bluff. He's been under this bond for 4 years.
We'll get to that in a minute, but I'm looking at the quote now that I see the full quote. About
Judge is taking issue with this full quote.
The rule of collateral estoppel should be considered with realism and rationality. But that's through the prism of you and your client.
The judge says, but that's through the prism. That is through the prism that you are ascribing. Okay, hang on.
Of you and your client.
That's through the prism of you and your client. He's basically saying you have rose-colored glasses on, and that's the view that you're looking at. I don't see it that way. Oh, this is so good. These quotes are so that is so this quote is so on fire. I can't and the prosecuting attorney is just sitting there going, "Uh-huh, Your Honor, uh-huh." This is great.
You are the one ascribing what the realism and rationality should, right?
No, I think the rule of collateral estoppel and what Ash is saying is that any court, not being my client, we don't apply. Any court should apply.
But the realism and rationality that I'm supposed to consider is coming from you. Right?
The realism and rationality is coming from you.
Not to be applied with the hyper-technical and archaic approach of the 19th century pleading book, but with realism and rationality. But the realism and rationality that you're asking me to consider and then accept is this idea that the jury found Mr. Valle not guilty based on the state's inability to disprove justification. So that's your argument.
Right. He's saying you're arguing that the jury was unable to convict him or acquit him based upon your. This is the idea that the jury found Mr. Valle not guilty based on the state's inability to disprove justification. That's your argument. That's your realism. That's your rationale. But based on he's saying these are your ideas. This is your thought. This is your process. It's not mine.
And the state presents a position that says, Judge, give us a second chance to retry this young man. And we have the reason why we should do so. We feel that we don't violate the law in doing so. I want the court.
Okay, so you let me know in the comments, do you think whether or not the judge, Kevin Russo, will deny Raul Valle's motion to dismiss? I think the answer is yes. And the reason why he's going to deny it is the following. Based upon the oral arguments that the defense is presenting, they're saying if we could just only go back into the minds of the jurors already spoke. But the judge is like, we can't do that. And we are just making facts that are not in evidence, right? You're assuming facts, not in evidence. You're assuming facts that the jury made these decisions. You don't know that for sure. They spoke, they wrote it on this paper. That's it. So he had great skepticism towards the defense and his double jeopardy logic. He questioned them thoroughly about some of the cases that they had cited and how that fits into what his theory is. So, under Connecticut law, when a jury is deadlocked on specific counts, a mistrial is declared for those charges. The state possesses a clear, standard legal right to refile and retry a defendant on any deadlock counts. There's no ifs, ands, buts, or doubts about it, unless you can find that the trial court erred in some way. And in Williams, the trial court erred because it didn't make those instructions to the jury. That's why jury instructions are very, very important. But Mr. Crossland is not questioning the jury instructions. And in fact, he just said the judge made great jury instructions. So you're not questioning that. All right, so I'm going to go ahead and stop my TikTok stream. I'm going to continue here on this one so I can just finish this out. Thank you for joining me, TikTok. Make sure to do the likies, the subscribey things, and we'll be back again tomorrow. I'm not sure what time, but make sure you like and subscribe and you get notifications, and we'll let you know what we're going to cover tomorrow. So thanks for joining me, TikTok. We'll see you again tomorrow. Same bat channel, but don't know the bat time. Bye. All right. Let's continue on with this. And I'm going to make it go a little bit faster.
I want the court to tell the state that collateral estoppel in criminal cases should be applied in a rational
Well, let's see
way.
what Mr. Durso is realism and rationality is before I even consider acknowledging it that way. Chances are I probably won't. But I have 4 very good questions for you, and the only reason why I'm asking Mr. Crossland is this is a judicial thing. So when a defendant files a motion to dismiss, and in your motion to dismiss dated April 15, you cite 8 different grounds. Actually, 8 and a half. We'll get to the half in a minute. But you cited 8 different grounds in the April motion, and in the one from yesterday, May 31, you cited not an additional ground, but one certainly more involved, which is collateral estoppel. So you did not argue 3 grounds in the April 15, 2026, and I have to ask you now if you want to argue them or you're just going to rest on the papers. In other words. So in the April motion to dismiss, ground number 6, you said retrial is independently barred under Brown versus Ohio, the citation, because the pending reckless offenses or lesser included offenses of the intentional charges for which Mr. Valle was already acquitted. Do you want to be heard on that, sir, or no?
Judge, I thought I was going to get credit for it. A lot of times, Judge say, it's in the papers, I'm arguing. The big picture.
If you look at me right now and say, take that out of the papers, I will.
Yes, I don't want to belabor the point, Mr. Durso.
I will take that out of the papers.
I'm not abandoning any argument.
Okay.
And how can I want to be powerful? I don't want to,
Ground number 7. Dismissal is also warranted in the interest of justice pursuant to General Statute 5456. As Mr. Valle was 16 years old at the time of the incident and has remained under the burden of $2 million bond for nearly 4 years despite his 4 acquittals. That is a ground that you're citing for dismissal. Do you want to be heard on that, or do you want me to take the papers?
Judge, I take the papers.
All right. Number 8. The duration of these proceedings has caused substantial prejudice to the defendant, violating a Sixth Amendment right to a speedy trial on the factors set forth in Parker versus Pingo in citation.
Yes, Judge, I stand the papers.
I will remind Mr. Crossland that Mr. Valle has never filed a motion for speedy trial, and there isn't one pending. So I don't know how I can consider number 8. I don't think that ground is properly before the court. In Parker versus Wingo, which is 407 U.S. 514, a 1972 case, in that case that you're relying on, the defendant had filed a speedy trial. Mr. Valle has not.
No, and I make the record clear, Mr. Valle has not, the court gave me considerable amount of time to hire replacement counsel, who I am, which is me.
All right, but you're saying I should dismiss it because courts have violated his right to a speedy trial. He hasn't filed a speedy trial.
No, I'm not asking the court to make a ruling that the court's violating the speedy trial. I don't think it's prior counsel file either.
No.
But I just have to put everything in.
Finally, the half I referred to, it says, and you mentioned this in your PowerPoint, the alternative, the defendant requests an evidentiary hearing to examine the trial record, including verdict forms and jury instructions, to confirm that the acquittals necessarily resolve the issue of justification. Now, you have the jury instructions, you used them this morning. I remember I personally made a copy of them for you in the presence of counsel. Verdict forms, there were no verdict forms in the underlying trial. So I don't understand your alternative request for relief that's an evidentiary hearing. What witnesses would you call during an evidentiary hearing if there were no verdict forms and you have the jury instructions?
Yes, I think that question. And just so the record is clear, and Your Honor was graceful enough to make a copy of the state's motion that I received in presence of the state. But Mr. Dan, who's attorney clerk, last week.
Mr. Tirico.
Mr. Tirico was kind enough, his staff, I think, gave me a copy of the jury instructions. And you did give me a copy of the state's motion, which I received. But in terms of answering your question, as a catch-all, obviously my position is, as the court stated, you weren't at the trial, and if we are going to do anything short than dismiss this based on the constitutional grounds that I've articulated, I would think that the court may have to look at this. If the court's going to do this and have a hearing, have to look at who spoke, what they spoke. You said you didn't know if Mr. Valle stated that he did something intentionally. That's why I was saying we probably have to look at that.
But on a hearing, an evidentiary hearing, you're suggesting that I would, I don't know, so I'm asking the question, I would listen to the trial record? Because there are no verdict forms, so there's no reason to have an evidentiary hearing on that ground. Jury instructions, I don't know who you would call as a witness to that. And you want me to examine the trial record. How do you suppose I would do that?
Examine the trial record?
Yeah.
Read the transcript. But again, if we get to that, if we get there, obviously we strike some things that aren't pragmatic. But to answer them in isolation today, I think it's probably not most efficient because as we do these trials, we have conferences and we decide what we're going to strike. But I have to put it all in today. We can strike what we need later. But to answer the question, we're doing the trial record, we normally start with reading the transcript. For appellate purposes, when I take appellate case, I spend $8,000 the other day for a transcript. It's a lot of money. I have to read. That's how I read the record. If that makes sense.
How long was that trial? Almost 3 weeks. I'll consider the request, but the request includes me reading transcripts on a trial that took almost 3 weeks for me to determine, A, whether amended information is properly before the court, which is a procedural issue, not a trial issue, and then I should search the entire record to determine whether collateral stop or double jeopardy to be asked.
Yes, sir. I'm ambitious in a sense, but I think that in saying ambition, I think that collateral estoppel, which is a part of double jeopardy, you don't have to read all those transcripts to look at.
To settle the issue, I don't think I have to read any of them.
Yeah, I think so.
A very patient Mr. Durso, sir. I can take as much time as you like, and I will give you my divided attention, just like I did to Mr. Cross.
And so thank you for allowing me to.
You're welcome, sir.
Thank you, Ron. Counsel just indicated that Judge Murphy did a great job with the jury instructions. I just want to point the court to page 18 of the jury instructions where the court writes the jury.
Okay, hold on. Looks like the prosecutor is going to argue the same things that I just argued, which was, oh, you said the jury instructions were great. I'm going to slow this down a little bit. And yeah. Okay, here we go.
And this is, just to give you the full perspective, this was an excerpt from the latter part of the murder instructions to the jury. If you unanimously find the state has failed to prove beyond a reasonable doubt all of the elements of the offense of murder, you shall find the defendant not guilty of the crime of murder, and shall next move on to consider lesser included offenses to murder below.
So help you God.
If, however, you unanimously find the state has proved beyond a reasonable doubt all of the elements of the crime of murder, you shall next consider the defendant's claims of self-defense and defense of others. If you unanimously find the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or defense of others, or that the state has proved beyond a reasonable doubt one of the statutory disqualifications, you shall reject the defense and find the defendant guilty of murder. This will end your deliberations on count one. You will not deliberate on lesser included offense to murder. You will now deliberate on count two. If, however, you unanimously find the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of that defense alone, you must find the defendant not guilty of murder at count one, even though you have found the elements of that crime proved beyond a reasonable doubt. This will end your deliberations on count one. You will not deliberate on lesser included offenses to murder. You will now deliberate on count two. I read that excerpt to the court, as Councilman pointed out that the Mark did a great job of jury instructions. I point that out because the jury was instructed as to self-defense, and that it applied to all of the offenses charged as well as the lesser included offenses. The defendant asserted self-defense, and he's asserting that it was necessarily resolved in his favor, and the state would dispute that. The state opposes that argument. I believe during counsel's argument, he indicated that he wanted the court to look at the total picture, make inferences. Again, the jurors could not have considered lesser included offenses according to the jury charge, unless they believe the state failed to prove one of the elements of murder, let's say, intent to cause the death, we failed to prove one of those elements beyond a reasonable doubt. Self-defense never came into play there. And how do we know that? Because they went on to consider intentional manslaughter and indicated in that bill that we failed to prove an element of intentional manslaughter beyond a reasonable doubt. They never considered self-defense unintentional manslaughter. How do we know that? Because they went on to consider the lesser included offense of reckless manslaughter. And when they were considering reckless manslaughter, and of course, my argument applies to all four charges, Your Honor, I'm just simply using that as an example. They were hung. They could not agree. Did the state prove any of the elements beyond a reasonable doubt? And if they were hung on the essential elements of reckless manslaughter, just of course, benefits, the state had to prove, that there was conduct creating a grave risk of death, recklessness, extreme indifference to human life, and cause of death. They couldn't agree that, and we don't know, we can't speculate as to what element they believe the state, some believe that the state did prove it, some believe the state didn't prove it, but that's why they were hung. They never got to self-defense there, because why? Because self-defense is not an essential, the objective subjective standards of self-defense are not an essential element of the crimes charged or the lesser included offenses. Had they gotten to self-defense in this particular case, then they would have had to consider, after they found the defendant guilty of whatever charge they found him guilty of, they would have to consider whether or not we disproved one of those objective subjective standards beyond a reasonable doubt, or one of the disqualifiers. That never happened. And that's where I think counsel's argument is misplaced. And so again, I hate to beat a dead horse. I did file my memorandum here, which kind of reiterates what I'm arguing today, but the point is, the verdicts of acquittal that the jury reached with respect to the greater offense must have been reached by something other than self-defense. And we're presuming that the jury followed the court's instructions, and that's exactly what the instructions say. You are not to consider self-defense unless you first convict the defendant of one of those charges. Again, I read some of the cases that the counsel cited. He cites Williams, State versus Williams. Yeah, I would agree. Self-defense applies to reckless conduct, absolutely. Which is why the court instructed that if you get to the lesser included offense of recklessness, you have to, if you convict, you've got to consider self-defense. Well, they never got that far. And one more point: had the jury found self-defense, let's say on the murder charge, on the 2 assault, 1 charge is intentional, and the 1 assault 2 charge is intentional, we wouldn't be here today if they found self-defense. If they convicted on all those 4 charges, and they said, let's consider self-defense, the state failed to prove one of those objective subjective standards, or failed to disprove one of those disqualifiers. It's an outright acquittal all the way down, and the jury instructions were clear as to that. I think the crux of counsel's argument, unless I'm wrong, is essentially that he wants this court to essentially find that based on the verdicts of acquittal, the jury necessarily found self-defense. Again, those elements of self-defense, we don't have to disprove them. We have to disprove them, but that really doesn't come into play until there's a conviction. So we don't know how the jury would have come out on that issue because they never deliberated. I agree with the court's interpretation of Yeager. Again, that was a case. That case didn't even deal with self-defense. But here, the state's arguing that we're allowed to go forward on this case on the lesser included offenses that the jury was hung on, because reckless conduct is one lesser included offense of intentional conduct. But we're required to prove elements that are not the same as intent to kill, cause of death, or intent to cause serious physical injury, cause physical injury, dangerous. There are different elements of those charges, so that's why we believe that based on that record, we can go forward, because there are different elements of those 4 charges that we need to prove that were not part of the greater offenses. So they were part of the greater offenses, but doesn't preclude us from, that's why they're called lesser included offenses. It doesn't preclude us from moving forward on those charges because they're included in the greater offenses. The jury considered the intentional conduct. I guess we can all make a reasonable inference. Maybe the state failed to prove intent beyond a reasonable doubt. I know counsel indicated that the defendant got up there and said he intended to do this. I don't recall that in the record. I think the crux of the defense at trial was I had to react in self-defense. But that's not I didn't intend to do it. It's you acted in self-defense. Whether a jury bought that issue was never resolved. Obviously, you can't speculate as to what the jurors found, but I think what we could reasonably agree on is that in order for them to even consider the lesser included offenses, they would have had to have acquitted on the greater charge before getting there. And that does not include self-defense. Self-defense, again, applies all the way down in this case. Had it applied to the greater offenses, we would not be here having this discussion with an outright acquittal all the way down, including the reckless charges. And I think that's what counsel's argument is misunderstood, or perhaps counsel is misunderstood in regards to the application of the law in that respect. Touching upon, I know counsel asked the court to dismiss based on the grounds for speedy trial. I mean, the case happened, the incident happened in May of 22. 3 years later, we were having a trial. So he had a trial already in this case. It's not like we're unduly delaying this case moving forward because we're having this argument here. So I don't think that that's proper grounds for dismissal. Additionally, the defendant was released on bond by Judge Murphy. The state's position erroneously. He should have been released because the case should have just been put back on the docket on pretrial, and we could have had a discussion with regards to how to proceed from there. Instead, it was no next court date. Conditions of release were eliminated, essentially. So he hasn't been burdened with that in over a year, almost a year. So again, I don't think that that's good grounds to dismiss the case. I know counsel cites 5456, permitting the court to dismiss the case. Under that scenario, the reliance on 5456 in this respect, based on his argument, is based on motivated secondary stemming from having to face a retrial. Right? For the state versus alien on 22 common 4 in our memorandum. Again, he's failed to identify any insufficient evidence or cause, much less the existence of a compelling circumstance for this court to dismiss the charge based on 5456. So again, I read the memorandum initially filed by counsel. We had emailed counsel our memorandum back on April 27th. I did show counsel a copy of my email that was sent to his email. He put on the record here that he never got it. We did send it, so it wasn't, we did not send it. So I don't want the record to reflect that we forgot to send it. We did send it. I don't know if there's an issue on his end of the email system, but it was sent, and I copied the clerk on that email. And the clerk indicated he had received it as well. Again, I don't know if the court goes outside the record to look and see whether or not the jury actually ever reached self-defense. I would argue that the media's been covering this case ever since day one, and I know that there's some footage out there of one of the jurors indicating they never got to self-defense. So that's where they point the court in that direction. If that's the case, then I think the defendant's argument fails as to why this case should be dismissed. With regards to whether or not this case is properly before the court, I submitted that you do have a subject matter jurisdiction once again. The information that was filed in this case, right after the purpose of acquittal and mistrial was declared on lesser included offenses, was done to reflect the charges to which the jury could not agree on. And we did that so that there would be some charges that were reflected in the file. Do we necessarily believe we had to do that? I would argue not necessarily, because the charges were still pending. Those lesser included offense charges were still pending. The defendant was on notice of those charges when he was charged with the greater offenses. So for all those reasons, Your Honor, I believe that the motion to dismiss should be denied.
Just a question for the state. I imagine it's the state's position that the elements of reckless conduct, some of those elements are different than the elements of intentional conduct.
That's correct, and I touched upon that, I'm sorry, I wasn't articulate with regards to that, absolutely, they are. But, you know, reckless indifference manslaughter, for example, we have to prove conduct leading to risk of death, recklessness, extreme indifference to human life, cause of death. Those are different elements from intentional manslaughter, from murder, gross assault, first degree, we have to prove conduct leading to risk of death, recklessness, extreme indifference to human life, cause serious physical injury. Again, those are the elements that are different from assault and first degree intentional. And with the gross assault in second degree, with recklessness, plus serious physical injury, the danger syndrome. Again, those elements are different from assault and second degree intentional. So, to the extent that I did not articulate that well in the report, that is the state's position.
Mr. Crossland, you asked for just a few minutes for rebuttal, sir.
Yes, thank you, Judge. Judge, I respect the counsel's position, and to the extent they overlooked the crux of what needs to be proven constitutionally in order to go forward. I think that their resuscitation elements still fail to meet the high burden that must be proven in order to retry. With that, I would say that the state has articulated that the Honorable Judge Murphy may have erred on several grounds. I respectfully disagree with their position. I think she was very diligent in dealing with this case, very civil, and had a lot of judicial temperament, addressing both the families of the victim as well as my client, Mr. Valle. And I think that she erred in no way, and she did continue the conditions that was on, and her record is complete that she made her error. But counsel is entitled to this position if that's what it is. I would like the court to strike any attempt, although it wasn't said with a deep breath, to reference what a jury might have said in some Hollywood setting in terms of where they reached in terms of self-defense. I think the counsel referenced that they might have said an interview that I never saw or some scuttlebutt about a jury might have told some press about self-defense. I suppose to strike there, that's not evidence. I think it's inappropriate.
I will not use any juror comments. They're discharged, they're no longer under oath. But I should also say, in your request of me asking to strike that one sentence that Mr. Durso said, the defense also sent me via email a portion of media where you had directed me to watch it because you said it captured your argument perfectly. So if you're asking me to ignore Mr. Durso's statement, I would tell you I have to equally ignore what you sent me in email.
By the way, I've never got a copy of that, so I don't.
I would only respond by saying two things. The portion that the court is talking about that I sent was also in my PowerPoint, and it was based on my motion, and it was shared with an individual who put that together and just posted it on TikTok. So it's not media in terms of one crime or this fall.
Well, it really was. I mean, if you asked, I did not look at it.
Okay.
But if I had clicked on it, my limited ability to do those things, it was a media report that you said captured your argument almost perfectly. What's good for the goose is good for the gander. If you're asking me not to consider Mr. Durso's one sentence, I'm not going to. But I also did not consider the email that you sent.
And just as respectful, obviously, as we spent the early part of the morning together and during my presentation, the bench was pretty hot. Not too many questions for the state, but 20 years of doing this, I've come to accept that. I hope the hot benchness wasn't an articulation that my arguments for it, and a cold bench, meaning no questions and no interruptions for the state, wasn't an endorsement of the state's argument. We could only fathom, again, like the jury, it's a secret thing. We don't know what your honest thinking. But nonetheless, I appreciate the hot bench, and I hope I answered the questions. And to be fair, as you're stating you are, I appreciate you pointing that out. I would go on to state case 18 of jury instructions, where the state states, when they read second paragraph, if, however, to the jury, Judge Murphy's charge, if, however, you unanimously find that the state has, in the affirmative, proved beyond reasonable doubt all the elements of the crime of murder, you shall next consider the defendant's claim of self-defense and defense of others. So when the state articulated that the jury had to have found Mr. Valle guilty of murder, or displaced. It doesn't work that way pragmatically. Obviously, they don't get to come out and say, hey, you found guilty, now we can go in. They listen to all the evidence in the trial. They listen to the entire jury instructions, and all this is happening in real time pragmatically. So my question to the court would be, if the state's contention is that it was a hard stop, something happened and they went on, I would argue that can't happen that way pragmatically. And so when the state says that you only consider self-defense if you convict, and that's their words, pragmatically, you convict. The judge said, in your own mind, in your own deliberations, if you find that they have proved beyond reasonable doubt, then all the elements, and those are the same elements that exist for the charge that the state is looking to go forward on now. I have the substitute information, or new information. The state's looking forward. They filed an information now in July, stating assault in the first degree, assault in the first degree, and I believe assault in the second degree. The elements of those now new amendments are the same, and I pointed them out in the slides. 1, 2, and 3. Those are 3 elements: intended to cause harm with a dangerous weapon. Those are the same elements that they're going to have to prove in a new trial if they go forward. So the state is arguing that according to page 18 of jury instructions, that they must convict first. The language says if you find that the state has proven, then go to self-defense. And I think the state also highlighted that something of, we don't know what the jury had in mind when they reached these verdicts. I think we're all in the same space. But yet still they make a conclusion that they didn't consider self-defense because they were told not to. They absolutely were told to. They said, if you find that the state has proven beyond reasonable doubt, you can consider self-defense. Now, we don't know if they even found the state proof beyond reasonable doubt that was intentional. We just know the record says that if my client's defending himself with a knife, and then he testified that he did what he did in self-defense, then there was intention. So with that being said, I think pragmatically, my only response as I get to rebut as the state does, most of the time since it's my verdict, or I go first, I would ask the court to just be mindful that on reason and rationality and being pragmatic, the jury listened to everything, heard all the elements, and applied the law accordingly. And I do believe that the elements of the pending charges are the exact same elements that the state will have to prove at the retrial. Thank you, Judge.
Mr. Durso, anything further?
Nothing.
Thank you, Mr. Crossland, Mr. Valle, Mr. Durso, staff, always great. We're going to give them the recess they deserve. For the Part B, we will reconvene at noon. We'll thank the press for coming today as well. With it, I'll take it on the papers. So let's give it a 90-day date, but I am extremely confident that I will have a ruling before now. August 28th, same conditions apply. Again, the decision will be a written decision, which the parties will receive. I anticipate having that decision much sooner than that.
I think so.
You're welcome. Thank you.
Oh boy. Okay, that was long, and I'm sorry I made it even longer. I apologize. It's just, it's a lot. It's a lot. But I wanted to go through everything because I wanted to hear everything. I wanted to hear both sides of the issue. I wanted to hear what Mr. Crossland had to say. I wanted to hear what the prosecution had to say, and I want to hear what the judge had to say. And I love a hot bench. I love it when it's done tastefully, right? There are some hot benches who are just like super accusatory, and there are some hot benches who are like, hey, I want to hear what your thoughts are on this. I want to hear it respectfully, right? So that was a lot. All right. Let me know in the comments what you think. Do you think that he is going to get his case dismissed? I don't think so. Those were not strong arguments. The arguments he made were just like, but this over here and this over here. But don't look at this, Your Honor. Look at this over here. Don't be fooled by the man behind the curtain. Look at this over here. Look at this shiny thing over here. So I don't think it's going to fly. I don't think any of his arguments were clear enough, because one minute he's like, the prosecution has a right to retry him. The prosecution doesn't have a right to retry him. So But this is our first look at Mr. Crossland, and we appreciate that. So judge said it was going to be 90 days. We are already 38 days into those 90 days, so halfway through. So we're expecting a judgment sometime soon. He said by August 28th. Hopefully that happens prior to that. And then where does this case go? Well, once there's not a motion to dismiss, then it gets back on. It's off the rails right now. It's really off the rails. It'll get back on the rails, and then we'll proceed as such. So I assume if the judge dismisses it, then they're going to put it on the rails as all the discovery in, are there any experts, what, because this is a new lawyer. He's retrying the case. So he has to, it's all brand new to him. So he has to been able to reasonably given some time to go through the case, et cetera, et cetera, et cetera. But he's doing his due diligence. He's got the spaghetti. The spaghetti's not going to stick right now, but will some other things come out that it's going to stick? So we'll see. Is it going to be a different trial than the first one? That will be interesting as well. And plus, also let me know, did you see the first trial? So I saw parts of it. That was my very first case that I covered. I only got through like a little bit of it because I wasn't sure that this is what I wanted to do. Didn't know if I had the time or the bandwidth to do so, but I dived in just after that case. So thank you all for watching. Let me know in the comments what you think. Thank you. Bye-bye. Thanks for watching Legalese 123. If you like what you saw, please like and subscribe for more content.